Okay, so today we're going to look at civil remedies. As part of Unit 4, Outcome 2, you're required to know the purpose of civil remedies and types of civil remedies, including damages and injunctions. So again, damages and injunctions are listed specifically in the study design, so you must know both of those. Just generally, the purpose of civil remedies is to restore the injured party or the plaintiff to the position they were in before the harm occurred. Now, sometimes we're able to do that effectively, particularly if there's a loss of money from a loss of income or medical expenses. We can compensate them exactly for the amount of money that they lost. But if it involves bodily injury or emotional damage or pain and suffering, then remedies aren't as effective as being able to do that. Damages are a sum of money granted to the plaintiff against the defendant in satisfaction of the claim by the plaintiff. So if the plaintiff sues the defendant for negligence, they may claim $1 million in damages, and the jury might award that to them, and then the defendant has to pay that money. They're essentially compensation for the infringement of their rights. Civil law is about protecting individual rights, and damages help to compensate people when their rights have been infringed. They're by far the most common remedy sought in civil cases. Damages have four main types that you need to know. There's compensatory damages, nominal damages, contemptuous damages, and exemplary damages. So firstly, the compensatory damages. The purpose of compensatory damages is to restore the plaintiff to their original position. It's to figure out exactly how much money they've lost and restore them back to their original position with that amount of damages. That is not always possible if there is physical injury involved or emotional or pain and suffering or something along those lines. So they can be specific damages, which is when you have a precise monetary value, whether that's loss of earnings or medical expenses that you can compensate them for exactly. General damages are a general estimate of loss that can take into consideration things like future loss of wages, long-term job prospects, and pain and suffering. They're a general estimate, and again, they're not easily quantifiable. And finally, aggravated damages can be awarded to compensate the plaintiff if the court feels that the defendant's conduct injured the plaintiff's feelings by causing humiliation and insult. Nominal damages really is when the purpose is to make a legal point. It's when a plaintiff seeks a small amount of money to make a point about legally being in the right. So they're not seeking a large amount of damages, just a small amount. They want the court to say publicly that their rights were infringed. And they're common really in defamation cases where somebody feels they've been defamed. They're not seeking a large amount of damages, but they just want to show that what was said about them was untrue. A good example recently in the Andrew Bolt racial vilification case, where a number of prominent Indigenous Australians took Andrew Bolt to court for a series of articles he wrote about them, claiming that they used their indigeneity for their own individual benefit, and they won that case. But they just sought a small amount of damages, and really were just seeking to have it on the record that Andrew Bolt was wrong to write those articles. Contemptuous damages are, again, a small amount of damages. The purpose is really to show contempt for the plaintiff's claim, to show that the claim, while it may be legally right, it's not morally defensible. So the plaintiff doesn't actually seek contemptuous damages. They would be seeking compensatory damages and maybe exemplary damages, but the court decides that even though legally their claim is correct, it's not morally correct. Again, it's common in defamation cases. An example of Bruce Grobbelaar, who was a goalkeeper for Liverpool, who was convicted of match fixing claims, and he was awarded a contemptuous damages of £1 when he sued a British newspaper for defamation. So the court said legally he was right that he'd been defamed, but not morally, because his reputation had already been tarnished. The final category of damages are exemplary or punitive damages. The purpose of exemplary damages is to punish and deter the defendant. The only civil remedy that seeks to punish. They're used where conduct is wanton or malicious or violent or cruel or insolent or in scornful disregard of the plaintiff's rights. So when a defendant his actions is so bad or so reprehensible that the court sees fit to award punitive damages, so above what would just compensate the plaintiff. An example recently was when Christy Fraser Kirk sought punitive damages from David Jones. She sued them for a large amount of money to firstly to be compensated, but also to punish David Jones for their behaviour. She ended up settling out of court, but also that the large amount of money served to deter not only David Jones but other large companies to reappraise their sexual harassment policies. The second category of civil remedies that you need to know are injunctions. An injunction is just a court order, and the purpose of an injunction is to essentially rectify a situation caused by the person who was found to be in the wrong. So types of a common type of injunction is a restraining order, where a person is ordered to stay away from a person for a period of time. Injunctions, again, they're court orders that can be either restrictive or prohibitive, i.e. they order a person to refrain from doing something, so perhaps a restraining order that stops a person from coming within a certain distance of another. They can also be mandatory. They order a person to do something, so it may be to fulfill a contract or to rehire a person or something along those lines. Injunctions can be either interlocutory or temporary, so until a case is heard. They can also be perpetual or permanent, and they're generally issued after the case has been heard. An example of how injunctions can work, so just imagine that if a developer was planning on demolishing an old building, and certain people were claiming that it should be heritage listed, and they wanted to take that case to court, then the court would be able to issue an interlocutory or a temporary injunction that would stop the building from being demolished until the case is heard. And then once the case is heard and the court decides whether the building should be protected, then the court could issue a perpetual injunction that would prevent the building from being demolished from then on. And that's it.